In July 1884, the yacht Mignonette set sail from Southampton to Sydney with a crew of 4: Tom Dudley, Edwin Stephens, Edmund Brooks and Richard Parker. Dudley, the captain, faced financial struggles and the crew embarked on the voyage hoping for a fresh start. Unfortunately, the journey took a grim turn when the Mignonette sank in the South Atlantic Ocean, leaving the crew stranded in a lifeboat for several days. To survive, they resorted to cannibalism by killing and consuming a crewmate. Our episodes deal with serious and often distressing incidents. If at any time you feel like you need support, please contact your local crisis centre. This episode discusses cannibalism and murder. It may not be suitable for all listeners. Listener discretion is advised. The yacht Mignonette was a 52-foot cruiser built in 1867. It was an inshore boat, not made for long voyages. Australian lawyer Jack Want purchased it in 1883 for leisure. The vessel could at decent cost be transported to Australia by sailing, but its size and the 15,000-mile voyage daunted attempts that year to find a suitable crew. It was sailed to Sydney from Southampton on the 19th of May 1884 with a crew of 4: Tom Dudley, the captain, Edwin Stephens, Edmund Brooks and Richard Parker, the cabin boy. Parker was a 17-year-old and an inexperienced seaman. On the 5th of July, Mignonette was running before a gale, around 1,600 miles northwest of the Cape of Good Hope. The vessel was not struggling, and Dudley gave the order to heave to so that the crew could enjoy a good night's sleep. As the manoeuvre was completed and Parker was sent below to prepare dinner, a wave struck and washed away the side of the ship. Captain Dudley instantly realised that the yacht was doomed and ordered the single 13-foot lifeboat to be lowered. The lifeboat was of flimsy construction, with boards only 6mm thick, and was hauled in the haste to get it away. The Mignonette sank within 5 minutes of being struck, and the crew abandoned ship for the lifeboat, managing only to salvage vital navigational instruments, along with 2 tins of turnips, but no fresh water. Dudley managed to improvise a sea anchor to keep the lifeboat headed into the waves and maintain her stability. Over the first night, the crew had to fight off a shark with their oars. They were around 700 miles from the nearest land, St. Helena or Tristan. Dudley kept the first tin of turnips until the 7th of July, when its 5 pieces were shared among the men to last for 2 days. On or around the 9th of July, Brooks spotted a sea turtle which Stephens dragged on board. This yielded about 3 pounds of meat each, plus the bones, which along with the second tin of turnips, lasted until the 15th or 17th of July. They were unable to drink its blood after it became contaminated with seawater. The crew failed to catch any rainwater, and by the 13th of July, with no other viable source of liquid, they began to drink their own urine. It was probably on the 20th of July that Parker became ill through drinking seawater. Stephens also became unwell, possibly from the same cause. The decision to choose a victim who would die to feed the others was possibly first discussed on the 16th or 17th of July, and debate seems to have intensified on the 21st of July, but without a resolution. On the 23rd or 24th of July, with Parker unconscious and probably in a coma, Dudley told the others that it was best that one of them die so that the others would survive, and that they should draw lots or straws to decide. Brooks refused, and that night Dudley again raised the matter with Stephens, pointing out that Parker was probably dying and that he and Stephens had wives and families. They agreed to leave the matter up until the morning. The following day, with no prospect of a rescue in sight, Dudley and Stephens silently signalled to each other that Parker would be killed. Killing Parker before his natural death would mean blood to drink. Brooks, who had not been party to the earlier discussion, claimed to have signalled neither assent nor protest. However, Dudley always insisted that Brooks had assented. Dudley said a prayer, and with Stephens standing by to hold the youth's legs if he struggled, pushed his penknife into Parker's jugular vein, killing him instantly. In some of the varying and confused later accounts of the killing, Parker murmured, "What me?" as he was slain. The three fed on Parker's body, with Dudley and Brooks consuming the most, and Stephens very little. The crew also finally managed to catch some rainwater. Dudley later described the scene, quote, "I can assure you I shall never forget the sight of my two unfortunate companions over that ghastly meal. We all were like mad wolves. Who should get the most? And for men, fathers of children, to commit such a deed, we could not have our right reason." On the 29th of July, the crew sighted the sail of another ship. Dudley, Stephens and Brooks were picked up by the German sailing bark Montezuma, which returned the men to Falmouth in Cornwall, England. On arrival in Falmouth, the survivors attended the Customs House, and Dudley and Stephens entered statutory statements under the Merchant Shipping Acts required in the event of a shipping loss. All three were candid, with Dudley and Stephens believing themselves to be protected by a custom of the sea. This specific custom, which was also known as the delicate question, or the proper tradition of the sea, specified that in case of disaster, when there was not enough food for the survivors, corpses could be eaten. If there were no bodies available for consumption, lots were drawn to determine who would be sacrificed to provide food for the others, as long as the lottery was fair, giving everyone an equal risk of dying to become food for the others. This was considered entirely legal and justified by the circumstances. On the whole, sailors and the general public knew and accepted this protocol of cannibalism to survive ship disasters. The only cases when cannibalism in maritime disasters sometimes led to legal prosecution was when the lotteries were fixed or absent altogether, in violation of the accepted custom. Such violations were nevertheless common enough. Captains and other crew members were often unwilling to put their own lives at risk, as the rules of the custom demanded, instead choosing to sacrifice those they considered more expendable, such as slaves, young boys and passengers, to serve as food for the others. The duty police sergeant of the Falmouth Harbour Police, James Laverty, was nearby the depositions and overheard the statement given to the customs officer. He later questioned Dudley about the means by which he had killed Parker, taking custody of the knife and promising to return it. The depositions were telegraphed to the Board of Trade and to the Registrar General of Shipping in Basinghall Street in London. While the survivors were making arrangements to rejoin their families, Basinghall Street advised the men be detained. The Board of Trade gave conflicting advice to take no action, but inform the Home Office, which was closed for the weekend. Laverty sought warrants for the men's arrest for murder on the high seas, which he obtained later that day from the Mayor, Henry Liddicote. Dudley, Stephens and Brooks were held in the police station until their appearance before magistrates on the 8th of September. Dudley appeared to have been confident that the magistrates would dismiss the charges. Liddicote visited the men to apologise for the inconvenience, but all magistrates had recently been instructed to seek advice from the Treasury solicitor in all murder cases, and the clerk probably prompted Laverty to ask for a remand in custody and adjournment while advice was sought. Local solicitor Harry Tilley appeared for the men and requested bail, but after the magistrates, including Liddicote, had consulted, they were returned to the police cells until Friday. By Wednesday, the file had been passed to Home Secretary Sir William Harcourt. That day, Harcourt consulted with Attorney General Sir Henry James and Solicitor General Sir Ferrer Herschel. Harcourt took the decision to prosecute, the system having not clarified the law given the events of another similar incident involving James Archer. On the 9th of August 1874, the collier ship Euxine was lost, and its second mate, James Archer, took charge of one of the lifeboats with 7 other survivors. Archer and 4 survivors were picked up on the 31st of August. Archer candidly admitted that he and August Muller had killed and butchered Francis Schufus by all drawing lots. They were ultimately landed at Batavia Road, where the acting British consul, William J. Fraser, took their surprisingly honest depositions. The men were then shipped to Singapore with Fraser's depositions to shipping master Henry Ellis. Ellis consulted Attorney General of Singapore, Thomas Bradell, but then wrote to the Board of Trade in London that no further action was necessary and the men were free to find another ship to serve. Singapore Governor Sir Andrew Clark had ordered the men arrested, and when he informed the Colonial Office, they insisted that he hold a judicial inquiry. Prosecution was started in Singapore, but ultimately dropped after extended procedural wrangles as to whether Singapore or England was the most appropriate jurisdiction. By the time of the bench appearance on Friday, public opinion in Falmouth had swung behind the defendants, especially after Parker's brother Daniel, also a seaman, appeared in court and shook hands with the 3. The case was re-adjourned until the 18th of September, granting bail, the Home Office having hinted that this would be appropriate. The 3 men returned to their homes while the case began to appear across the British and international press. It soon became clear that consensus lay on the side of the defence. Harcourt was disgusted by the public sentiment and became even more intent on a conviction. William Otto Adolph Julius Danckwerts, a barrister of only 6 years but a specialist in wreck inquiries, was briefed for the prosecution, but soon realised that public sentiment and the lack of evidence posed formidable difficulties. The only witnesses were the 3 defendants themselves, and their right to silence would impede any formal proceedings. A confession was only admissible against the person making it, not his co-defendants, and the contents of the depositions were probably inadequate to convict. When the case was heard by the magistrates on the 18th of September, Danckwerts told the court that he intended to offer no evidence against Brooks and requested that he be discharged so that he could be called as a witness for the prosecution. There is no evidence that Brooks had been canvassed about this, and the magistrates agreed. Danckwerts opened the prosecution case and called as witnesses those who had heard the survivors' stories and Brooks. The magistrates committed Dudley and Stephens to trial during the winter days in Exeter, but extended their bail. The trial opened in Exeter on the 3rd of November, before Baron Huddleston. Arthur Childs, QC, led for the prosecution, and Arthur J.H. Collins, QC, for the defence, paid for out of a defence fund that had been established by public subscription. Huddleston was well aware of the passion of the local jury, probably aware of the failed prosecution in Archer. Sir William Robert Grove had initially been listed to take the court that session, prompting speculation that Huddleston was substituted to ensure a safe pair of hands, with his by reputation opinionative direction of trials. The jury was impanelled and sworn, being composed of almost the same jurors as had sat with the judge the previous day in a murder case that had resulted in the death penalty. Dudley and Stephens pleaded not guilty. Charles opened for the prosecution, outlining the legal arguments and dismissing the defence of necessity. He also dismissed the insanity defence. It was clear from the depositions and Dudley's prayer that they were aware of the gravity of their actions. Charles did not suppress the dreadful conditions on the boat and suggested an ultimate appeal to royal clemency. Words followed between the judge and Collins, which showed the former had made up his mind on the law and was not interested in hearing any submissions from the defence. Huddleston had already planned how he would ensure a guilty verdict and settle the law on necessity once and for all. He would invite, in robust terms, the jury to return a special verdict, stating only the facts of the case as they found them, but giving no opinion on guilt or otherwise. It would then be for the judge to decide whether the facts found amounted to guilt. Though special verdicts had once been common, none had been returned since 1785, and the jury in any case retained the right to return a general verdict. Huddleston was further determined that the legal question would be settled by a reserved bench for authority. Hence, he planned to adjourn the trial after the special verdict and reconvene with fellow judges to pronounce guilt. Collins would have his opportunity to argue the law in front of the expanded bench. Charles produced the various accounts and depositions written by the defendants and the evidence that Mignonette was registered in Britain for jurisdiction under Section 267 of the Merchant Shipping Act, 1854. He then called for evidence from the various people who had spoken to the defendants on their arrival in Falmouth before calling Brooks. Brooks provided a compelling account of Dudley and Stephens' actions and his distancing. In cross-examination, Collins did not challenge his account, but made him confirm the appalling conditions on the boat, Brooks's own cannibalism, their inevitable death without recourse to Parker's body, and the belief that Parker would have died first. Collins addressed the jury on necessity in his closing speech. The judge gave them a binary decision: accept his direction to find the men guilty of murder, or return a special verdict. Without waiting for a decision, the judge produced a special verdict he had written the night before and invited the jury to indicate their assent to each paragraph as he read it out. It read that the men probably would have died within 4 days otherwise, and that Parker probably would have died before the men, and that at the time of the killing, there was every probability that all 4 would have died unless one of them was killed and eaten. Though the jury tried to add some facts to the verdict, the judge insisted, perhaps not entirely truthfully, that their observations were already incorporated. The final words of the verdict were, "But whether upon the whole matter the prisoners were and are guilty of murder, the jury are ignorant and refer to the court." The judge then renewed the defendant's bail and adjourned the court to his rooms in the Royal Courts of Justice in London for the 25th of November. At some point after the trial, but before the special verdict was copied for the London Review, Huddleston realised that he had made a potentially serious error. In his original draft, he had described Mignonette as an English merchant vessel, but had altered this to read yacht. Further, he had described the lifeboat as an open boat, and not asserted its provenance on Mignonette. He now realised that he had admitted the critical finding necessary to give the court jurisdiction over Dudley and Stephens. Huddleston's solution was simply to alter his record of the verdict. On the 25th of November, the court sitting reconvened at No. 2 Court, the Royal Courts of Justice in London. Attorney General James appeared for the prosecution and immediately pointed out a problem. The Divisional Court of the Queen's Bench had an established authority to decide a matter of law with a panel of judges after referral from an inferior court, only by statute after a conviction, but there had been none. Attorney General James suggested that an alternative was to hear the case at the Cornwall and Devon courts, albeit at an unusual venue, but to add further judges to the bench, as all High Court judges had authority to hear court cases. Huddleston expressed his scepticism that judges could be added to a trial once it had begun. Moreover, he had been looking for affirmation from a superior court. By this time, Collins had become suspicious of Huddlestone's tampering with the trial record and requested the shorthand notes of the hearing. With the proceedings now in shambles, the case was listed for the 4th of December, and the defendants were ordered to attend in London, though on what authority is unclear. At a further hearing on the 2nd of December, James withdrew his suggestion of an augmented court and opined that the court should sit as the Queen's Bench Divisional Court. This should only have allowed 2 or 3 judges, not the 5 who eventually sat. Collins seems not to have taken the opportunity to challenge the jurisdiction or constitution of the court, possibly because of some agreement with the prosecution and promise of clemency. The Queen's Bench Division sat on the 4th of December under Lord Chief Justice Lord Coleridge. James appeared for the prosecution, leading Charles and Dankworth. At the beginning of the hearing, the report of the Exeter trial was read out, at some length, in its entirety. This allowed Collins to submit that the special verdict had been altered. As much was ultimately admitted, and it was eventually agreed that it was best that the special verdict be restored to the version agreed by the jury. The resultant attempt to challenge the jurisdiction was rejected by the judges. Collins submitted the court was not competent to return a verdict, as the Exeter jury had not given a conditional verdict, openly stating that the jury would find in accordance with the court's ruling on the law. This troubled the judges, especially Grove, but was dismissed as one of form. James submitted that there was no common law authority to support the proposition that necessity was a defence to murder. The St. Christopher case was rejected as a precedent because it had not been formally recorded in the law reports. Before Collins started his submissions, Lord Coleridge instructed him to confine his remarks to murder, dismissing the idea of necessity as a partial defence, leading to a conviction for manslaughter by analogy with the partial defence of provocation. Collins responded by citing the United States versus Holmes in 1842 and discussing the various theoretical and ethical arguments in favour of a necessity defence. At the end of his submissions, the judges withdrew. They returned after a few moments, and Lord Coleridge declared, "We are all of the opinion that the conviction should be affirmed, but we will put our reasons in writing and give them on Saturday next." After some technical legal discussion, Lord Coleridge committed Dudley and Stephens to Holloway Prison until Tuesday the 9th of December, when the court would deliver its reasons and its sentence. The panel found that there was no defence of necessity to a charge of murder, on the basis of legal precedents, nor on the basis of ethics and morality. To preserve one's life is generally speaking a duty, but it may be the plainest and the highest duty to sacrifice it. War is full of instances in which it is a man's duty not to live but to die. The duty in case of shipwreck of a captain to his crew, of the crew to the passengers, of soldiers to women and children, as in the noble case of the Birkenhead. These duties impose on men the moral necessity, not of the preservation, but of the sacrifice of their lives for others, from which in no country, least of all, it is to be hoped, in England, will men ever shrink, as indeed they have not shrunk. Further, the judges questioned who was qualified to make the decision of who should live and who should die, were the principle to be allowed. They further observed that such a principle might be the legal cloak for unbridled passion and atrocious crime. They were sensible of the men's awful predicament. It must not be supposed that in refusing to admit temptation to be an excuse for crime, it is forgotten how terrible the temptation was, how awful the suffering, how hard in such trials to keep the judgment straight and the conduct pure. We are often compelled to set up standards we cannot reach ourselves, and to lay down rules which we could not ourselves satisfy. But a man has no right to declare temptation to be an excuse, though he might himself have yielded to it, nor allow compassion for the criminal to change or weaken in any manner the legal definition of the crime. Dudley and Stephens were sentenced to the statutory death penalty with a recommendation for mercy. Collins still had the option of moving a writ of error to raise the very arguable issues of jurisdiction and constitution of the court, but he knew that the verdict in such an important case had been decided in advance, and Dudley and Stephens still anticipated an immediate release. By the 11th of December, there was still no announcement, and it was seemed that, their having been convicted, public opinion was moving against the men. Any exercise of the royal prerogative of mercy would be exercised by Queen Victoria on the advice of the Home Secretary, William Harcourt. Though Harcourt was personally in favour of the abolition of the death penalty, he was conscientious in his official duties. He took the judgment of the court seriously that the men were guilty of murder and feared that commuting the sentence to anything other than life imprisonment would mock the law. The Attorney General felt that a life sentence would not resist the attack of public consensus. He noted that the court had withheld a finding of manslaughter from the jury, which, had it been available, would have been the jury's verdict, and no judge would have inflicted more than 3 months' imprisonment. The Solicitor General concurred. Based on James's and Herschel's advice, on the 12th of December, Harcourt decided on 6 months' imprisonment. Dudley and Stephens were advised the next day, but were somewhat disappointed at being held for so long in custody. Dudley never accepted the justice of his conviction. The two were released around 7 a.m. on the 20th of May, 1885. After this judgment, there were no more cases of openly admitted cannibal killings on board British or American ships. This does not necessarily mean that they no longer occurred, but the sailors had certainly learned that more discretion was now required, since the custom had effectively been declared unlawful in the Mignonette case. In the 1890s, there were 2 more highly suspicious cases of maritime hunger cannibalism, but the survivors asserted that the eaten had died a natural death. Nobody seemed strongly inclined to try to prove otherwise, and no legal proceedings followed. In other countries, the defence of necessity to prevent starvation in the case of shipwrecks proved somewhat more durable. In the 1890s, 2 such incidents occurred on Norwegian vessels. In one case, lots were drawn to select a victim, while in the other case, 2 sailors were stabbed to death and eaten because the other sailors considered them close to death anyway. In both cases, the authorities investigated but decided not to press charges, considering the acts as justified by necessity. Thank you for listening to this episode. If you liked this episode, be sure to follow or subscribe to us wherever you get your podcasts. Follow us on social media and check out our website at shadowcrimes.com, where mysteries thrive and shadows speak.